Now, the proposed model operating requirements. The operating requirements are the requirements that the registrar imposes on the operator of the system. Now, as Jean mentioned earlier, National E-Conveyancing Development Ltd, a company owned by 4 states and some financial institutions, will be the first operator of the system. They haven't been approved yet, but they're building the system as we speak and spending a lot of time and money on getting it right. I know that they have done a number of consultations with stakeholders nationally, and I believe that they have presented a prototype of the system to the AIC in WA. So there is movement happening, and the development of the system is coming along well. So to become an operator of the system, the operating requirement sets the frameworks or the rules by which the operator must play. Now, as I said before, ARNECC, the registrars from all the jurisdictions, determine the model operating requirements, and then within the jurisdiction the registrars will adopt the model operating requirements. The model operating requirements will apply to anyone who wants to be an operator of the system. The national law doesn't say that there must only be one operator. It effectively provides that if you meet the eligibility requirements, you can apply to be an operator. So although at the moment it's anticipated we will have only one operator to start with, there is absolutely nothing to stop in the future other operators providing an electronic lodgement network. Having said that, the operating requirements require the network to be available nationally. To assist an operator to determine how it can comply with the operating requirements, we will be developing guidance notes which will give guidance on how an operator could meet its obligations. Now, I'm not going to go through the relevant legislation in the national law because I have already spoken to most of this before, and the provisions are in the national law. But effectively, the national law sets the framework for the approval of an operator of the system. Again, the operating requirements have to be made publicly available. Any changes to the operating requirements have to be made available and published before they take effect, unless it's an emergency situation. Now, the operator must be able to comply with the operating requirements at the time it applies to be an operator. It must continue to comply with them while it is an operator, and once it has ceased being an operator, it must comply with some provisions. And those provisions are to retain documents relating to the operation of the network and to implement a business and services disengagement plan, and I will talk about that at the end of the presentation. To be eligible to be an operator, there are a number of things you have to meet. You have to have an ABN. You must be a company and comply with the Corporations Act. You must be of good character and maintain best practice governance arrangements. And the expectation of the registrars is that the operator will comply as a minimum with the relevant Australian standard for good corporate governance. The operator must have sufficient financial, technical and operational resources to run the system. To establish that they have sufficient financial resources, we'll be looking for the audited financial statements and reports prior to approval and annually. To establish they've got sufficient technical resources, we will rely on their self-certification, because prior to commencing operation, comprehensive testing will be undertaken between the registrar and the operator, and it will become apparent if they don't have sufficient technical resources. They must have sufficient operational resources. The operator must also comply with the insurance rules. We require them to have professional and fidelity insurance, public and product liability insurance and asset insurance. The amount of that insurance is still being determined, so you'll see in your operating requirements consultation paper that that amount is blank. Don't think we're not going to put an amount in there, it's just that we're still trying to determine what that amount should be. If the operator uses contractors, then they must ensure that their contractors have the appropriate insurance as well. Because we want widespread take-up of the national system, there's an obligation on an operator to have a plan to encourage industry use of the system, and that plan must include the proposed service delivery model and the timing for the commencement of operations and the level of service in each jurisdiction. As I said before, the system must be a national system. It must be available to every land registry and to subscribers in all states and territories. And there are also various general obligations on an ELNO, which are quite standard, which are there as well. Before starting up the system, the ELNO must comprehensively test it to the satisfaction of the registrar. The registrar and the ELNO will agree a test plan and then test the system comprehensively in accordance with that test plan. The operator has a number of obligations regarding system security and integrity. Just as subscribers have obligations to ensure the integrity of the system, so has an operator. It must have an information security management system in place. Again, we're expecting that that information security management system will comply with the relevant Australian standard. It must ensure that only registered subscribers and their authorised users can access the network. It must make sure its system is virus-free. It must take reasonable steps to prevent unauthorised access, comply with data usage rules, and that means it must accurately present and use data. It can't change the data, and it must accurately check, collate and process data. The operator must use a reliable digital certificate regime using digital certificates issued by a gatekeeper authorised provider. Digital certificates in Australia are issued under what's called the Gatekeeper Public Key Infrastructure Framework, which is a Commonwealth Government policy setting out how digital signatures are to be used and issued in Australia. So there are a number of accredited providers of digital certificates like VeriSign, and the operator must ensure that it uses a properly authorised issuer of digital certificates. It must have an effective means of verifying that the digital certificates are current and that documents haven't been altered since they've been signed using the digital certificate. And it must notify subscribers if there's any compromise of a transaction or of the system from its point of view. In addition, there's a general obligation to make sure that the operator doesn't do anything to diminish the safety, security and integrity of the titles register. In addition to doing those things, the operator must have a system to manage risk within the network. It must identify and mitigate all the risks in operating the network. To do that, we expect it to have a risk management system in place, which is reviewed by an independent expert, and we anticipate that the risk management system again must comply with the relevant Australian standard. It must ensure that the use of the network doesn't result in a greater risk of fraud or error, and it must ensure that there's no net increase in the registrar's liabilities from the operation of the electronic lodgement network. Section 10 of the operating requirements deals with the minimum system requirements. These are the minimum things we want, or the registrars want, to ensure that the system operates properly. The operator must meet the minimum system requirements as to functionality. So it must have sufficient functionality in the system to enable subscribers to comply with their obligation in the participation rules and to enable the registrar to comply with any legislative obligations and policy requirements notified to the operator. It must use a data standard acceptable to the registrar. It must apply the registrar's business rules to documents prior to presentation for lodgement. So the business rules are all those things that are currently in our practice manual and that are in the operations section of our business that say things like every transfer must have a volume and folio number on it, every transfer must have the consideration stated, every transfer must be signed by the transferor and the transferee. They're the business rules, the rules around the actual transaction documents. So the registrars will provide those rules to the operator. These are our rules for documents to make sure they're properly completed, and the operator must apply those rules to documents coming in electronically. The operator must also provide services to enable subscribers to assess the integrity of the conveyancing transaction. And those are the sort of services like land title reference verification. So when you type into your document, certificate of title, volume number blank, folio number blank, if that title doesn't exist because you've made a typing error, then the system must come back to you and say, title doesn't exist. And you think, oh, well, I've obviously made a mistake, and check it again. Also, the system must provide a way of providing data from the register into the instruments. So existing title data, like the name of the existing registered proprietor, the volume and folio number, will be dropped straight from the register into the electronic document that you're preparing. So there will be a reduction in the opportunity for you to make errors. The system must also provide for lodgement verification. So when your documents are ready to go and the transaction's ready to proceed, you can request lodgement verification. And that's a call on the register to say, if I submitted this transaction, would it be accepted for lodgement? It's not accepted for registration. It's, will you take this transaction in the front door? So the system will provide a mechanism for that lodgement verification to happen. Also, it must provide for title activity checks and for a manner of calculating the lodgement fees. The LNO must ensure that the right templates are in the system, so you don't accidentally prepare a transfer based on a document form that was 3 years old instead of the current template. And as I said before, the operator can't send us anything unless it's first been checked that stamp duty has been paid or committed to be paid. If it's a settlement transaction, that settlement has occurred, and that the land registry lodgement and information fees have been paid, or there's been a commitment to pay those fees. Section 11 sets out the minimum performance levels for the system. We've put the minimum performance levels in to give subscribers comfort that this system is going to be a good system and operate efficiently and effectively. When you have a look in Annexure 2, you'll see that the minimum performance levels are quite high. For example, service availability, we expect the operator's system to be available 24 hours a day, 7 days a week, 52 weeks in the year. So it's fairly high standard that we're expecting of them. The corresponding side of that is, yes, we expect the operator's system, PEXA, to be up at all times, so you can prepare your documents in the middle of the night if you so desire. That doesn't mean you're going to be able to lodge them any time of the day or night with the land registry. The performance requirements simply relate to those on the operator. We also have performance measures for reliability, responsiveness, resilience, incident resolution and problem identification. The operator has to monitor and record against those performance levels monthly. Now, if anything goes wrong, which we hope it doesn't, we expect the operator to have a comprehensive business continuity and disaster recovery plan. That plan has to be regularly reviewed and they have to implement any reasonable recommendations of the review. Similarly, we expect the operator to have a change management framework in place so that changes can't be made to the system on an ad hoc, at-whim basis. Changes can't be made unless they're set out, they follow the procedure in the change management plan. Now, in relation to subscribers, the operator must make sure that the subscribers comply with the rules in relation to registration. It can't impose any unreasonable barriers to potential subscribers or unreasonably refuse to accept a subscriber. It must maintain a register of subscribers and users. It must obtain and retain evidence that the subscribers hold the relevant insurance. It must provide sufficient training resources to subscribers, monitor their compliance with the participation rules, and restrict, suspend or terminate a subscriber if directed by the registrar. Now, I've spoken about compliance monitoring in relation to the participation rules. There's a similar schema for compliance monitoring and compliance examination on an operator. But in relation to making sure that the operator complies with the requirements, we expect the LNO to continually monitor its own compliance, to demonstrate and report on compliance, and it does that by providing documents to us as evidence, giving us self-certification saying, yes, we've achieved these things, giving us independent certifications from independent experts, or providing a monthly report on some requirements like performance levels or an annual report. If you really want to dive into the detail of the how we expect an LNO to demonstrate compliance, I direct you to Annexure 3 in the operating requirements, which sets out for each clause of the operating requirements how we expect the operator to demonstrate compliance with the provision. In addition to Annexure 3, which is how we expect the LNO to demonstrate compliance, the Registrar can require an LNO to demonstrate compliance at any time. If there is any non-compliance by the operator, the Registrar has to be notified, and that must be remedied within 14 days. Now, I talked about an operator being able to demonstrate compliance by providing an independent expert's report. An independent expert is someone who's appropriately qualified, who's competent and who's not related to the LNO or its staff. And if an independent expert is required to give a report on some aspect, like is the information security management system satisfactory, we'd expect the expert to hold the appropriate accreditation by the relevant body. For example, in relation to an information security management system, we would expect the independent expert to be accredited by the Joint Accreditation System of Australia and New Zealand, which is a government-appointed board which certifies independent experts to provide certifications in relation to information security management systems. So we're looking for quality regulation, if you like, in compliance with relevant Australian standards. The compliance examination I've talked about, we have the similar procedures in the operating requirements for compliance examination on an operator as we do for compliance examination on a subscriber. As I mentioned before, the operator must provide the Registrar with a monthly report on compliance with the minimum performance levels and an annual report covering other compliance issues as well. The Land Registry will be providing data to the operator, and subscribers will be providing data to the operator when they complete information in the instrument templates. We expect the operator to indefinitely retain data entered into the workspace, documents, notifications going backwards and forwards between the subscriber and the operator, or the Land Registry and the operator, and documents relating to the registration of subscribers and users of the system. In addition, we expect the LNO to generate and indefinitely retain activity logs and audit records. And in addition, there is a data usage prohibition which prevents the operator without the Land Registry's prior approval from using the data provided to it for other purposes. Now, the Registrar's powers. As I've mentioned before, the Registrar has the ability to suspend or revoke an operator's approval, and that power can be exercised if, for example, the operator is in breach of the operating requirements, if false representation or warranty is given, if the LNO becomes insolvent, all those usual standard provisions that you'd expect to see. One important one is if the LNO ceases or threatens to cease carrying on business, then the Registrar can suspend or revoke the approval. Now, before it does cease or stop carrying on the business or a substantial part of the business, we would expect the LNO to implement its business and services disengagement plan to provide for a smooth transition to a new operator. Again, the business and services disengagement plan must be reviewed by an independent expert, and any recommendations must be implemented. Now, as I touched on in one of the questions, there is provision for jurisdiction-specific operating requirements. At the moment, no jurisdictions other than one anticipate there will be any jurisdiction-specific operating requirements. If there are, the operator must comply with those. Well, that's the end of the presentation on the operating requirements. I'd be happy to answer any questions, but before I do so, in case anyone has to leave, can I just remind you that the consultation papers And the overheads are available on the ARNECC website, which is www.arnec.gov.au, and that web reference is in your overheads, which you can collect on the way out. And in addition, a video of today's presentation will be available on Landgate's corporate website on Monday, and if you're looking for the web address of Landgate, it's on that little pen on your seat. If you have any trouble accessing the video of the presentation, please call Landgate. There's a contact number on the bottom of the little pad on your chair. We'd be happy to assist you with any technical difficulties. So do we have any questions? Oh, one more really important thing. Bruce will cane me if I don't mention this. Can you please provide us with your comments and feedback on the operating requirements and the participation rules by the 25th of May? There is a template feedback form on the ARNECC website, and we would really appreciate your comments because it will assist us to make sure that we get these documents right. Thank you for coming today, and are there any questions on the operating requirements?
Rachel, sorry. Just a couple of questions. Has the process commenced to actually find the first ELNO? Because I don't think anybody in this room is interested in taking on that job.
Yeah, it's envisaged that National E-Conveyancing Development will be the first ELNO. That's the company that's been set up by the 4 states, Queensland, Victoria, New South Wales and WA, and it now has investment from the banking sector, and they are currently building the system so that they can apply to become the first ELNO.
You mentioned in the presentation that the data will, to some extent, pre-populate in the standard forms. What actually occurs if the data on the register is out of date or wrong? For example, a deceased person or a married person. Are we able to change that? In the first and second release of e-conveyancing, I imagine you're going to have to change that in paper to correct it before it becomes an electronic transaction.
Obviously the banks might be potentially operators in the future. Is it going to be available for people using the systems to be able to work with multiple operators so they can be members of 2 different operating systems?
Because we're still trying to implement the first system, we haven't really got our heads around how it will work when there are multiple operators of an electronic conveyancing system. Obviously, we will need to amend the operating requirements so that there are interoperability between those 2 systems, but we're just trying to get the first system up and running before we consider multiple operators in the marketplace. But I'm sure in the future it will happen, just as the ASX used to be the sole provider of financial services in the stock market. Now they're facing competitors from other platform operators. It's a similar model to that.
I come from a law firm, so I'm just wondering, is there any regulation on the cost that this is going to be for subscribers?
Is your question, are there any restrictions on the costs the operator can charge a subscriber?
Exactly.
No, the operator is a commercial entity, so to ensure that it gets take-up to its system, it will have to have an attractive subscription price. A hub-based business works best when you have multiple participants. The more participants there are, the greater economies of scale there are for all participants. So if the operator sets its subscription price too high, it won't get the take-up that it needs. So there's an economic incentive for it to have a realistic subscription price. There is an obligation in the operating requirements that it have an equitable, fair and transparent pricing policy.
Sorry, one last question. Who determines whether it's going to be an electronic transaction or a payment transaction?
That will... I think that's probably an industry question, and it may well be that the joint form of general conditions will need to provide for nomination, is this an electronic transaction or not, and that will depend on what conveyancer you're using as to whether or not they're a subscriber to the system.
I would presume the banks will be pushing it for electronic conveyancing because they're not party to the contract.
Yes, I think that's correct. The banks receive economic efficiencies from using electronic conveyancing, so you may well find that even though the use of electronic conveyancing is not mandated by the registrar, that the economic imperative from the bank will be to use electronic conveyancing.
What about in the case what Val was talking about, where everyone agrees to use electronic conveyancing, all the parties are all going to be subscribers and there's all the banks involved, and then 2 days before settlement the ex-wife registers a caveat on the property which needs to be withdrawn at settlement, and then you have to get all the documents re-signed, new witnessing, the whole works. Otherwise you have to delay settlement.
That's a good question. That's an operational question I'm going to flick to Mr Mariano to answer.
Thanks, Craig.
Thanks, Rachel. Look, that can happen today, but it's not going to be as difficult as it can in the electronic environment. The unsigning happens as a matter of consequence. There will be the ability within the PEXA to be able to stop a settlement if something untoward like that happens. Also, prior to lodging the documents electronically, there is a service that Rachel hasn't spoken about today because that wasn't the purpose of the presentation. There's a lodgement verification service that checks with the land registry is can I register this dealing before it goes to settlement. So you will have 2 ways to do it. 1, we can check that no further caveats or other mortgages have come on, or 2, you will have that ability to also stop that settlement.
Thank you.
No, you will be able to create the withdrawal of caveat to remove that caveat. Again, we're talking about the releases. The first release, again, is about the discharge mortgage. So obviously withdrawal of caveats and caveats are out. But into the future, where you do have the stream of documents that Rachel spoke about and that ability to have the discharge, transfer, mortgage, withdrawal of caveat and caveat, if the caveat did come in there, that ability to create the withdrawal of caveat to withdraw the caveat would have to be in there to allow you to process that. Does that answer your question? Valerie, does that answer yours?
In regards to that, aren't we also going to be holding paper-based documents for this? We're going to have a paper transfer, a paper discharge, a paper mortgage that we have to hold in our own records, whether we be agents, banks, etc. That if we need to convert at the last minute to a paper-based thing, we will have those signed documents?
That would be a business practice you decided to implement. There'd be no obligation or requirement to hold a paper copy of a transfer executed by your client in the wet signature. You will be able to print off file copies for your records of instruments you have created in the system electronically.
So you could hold a paper-based record for your own records if that's where you wanted to go with it?
Yes. But there would seem to be little point in preparing a transaction electronically and doing a duplicate in paper. You lose the efficiency of the electronic environment if you're going to operate in that manner. But that's a decision for the subscribers. Any other questions?
What's going to happen to the Transfer of Land Act? Is the idea that it will be amended or will it be replaced with some new legislation?
Thank you for that question. That's an excellent question. In addition to passing a bill to adopt the national law as corresponding legislation, we will be amending the Transfer of Land Act to facilitate electronic conveyancing. Now, we're currently working on those amendments at the moment. When we have finalised our program of amendments, we will consult with the industry on those amendments to the Transfer of Land Act. And there may be consequential amendments to other acts as well, like the Duties Act. Thank you for that question. Any other questions? Well, I'd just like to thank you all for your attendance today. We really appreciate it, and we look forward to receiving your feedback in the template feedback form on the ARNECC website. Thank you again.